Going first segment, 3, 2.
Welcome. You're listening to the Best of Investing on Fox News Radio 910 a.m. This is the show where we present valuable information about real estate, the financial markets, and other economic business of the day. Make sure you keep a pen and paper handy. We have a new phone number, and we have an excellent guest today, and you're going to want to take some notes. And of course, I am honored to have as my co-host Mark Hahn of Pacific Private Money. He is the guru when it comes to investing in deeds of trust.
How you doing?
Okay, now, I was thinking about this, that for those who are new to our show, here's our format. Imagine a few guys sitting around a bar having drinks, without the drinks, unfortunately, talking about, next time, Mark, bring the drinks, talking about various business topics. I'm your host, Edward Brown, and I'm honored to have, I already went into that. Okay.
Oh, you can say it again.
I can say it again? Okay, Mark Hahn of Pacific Private Money. Now, Ken Winans couldn't be with us today. He is another co-host we have, and he's a featured Forbes columnist and sought-out speaker. Okay, now get your paper and pencil handy because we have a new phone number. Our new phone number is 888-912-1190. That's 888-912-1190. All right, use that phone number to answer the trivia questions for 3 vacations given away during each commercial break. That's right, we're still giving away 9 vacations during this show. The vacations are sponsored by Lighthouse Resort and Marina, which is located 1 hour northeast of San Francisco. Close enough for a nice vacation. The vacations are free. Their only request is a $75 cleaning fee to cover housekeeping expenses. Their website is lighthouse4fun.com. You can also reach them at 916-777-5511. They also have the best Mexican restaurant. Mention my name, you get a free appetizer with entree. Our website is bestofinvesting.com. Leave us an email, and you can friend us on Facebook. You can also email, well, the email would be edward@bestofinvesting.com. One more quick announcement. Don't forget, World Wraps in Corte Madera and Santa Clara is still giving our listeners a free smoothie with purchase of a wrap or bowl. Mention the Best of Investing. Go there for lunch today. Now, our special guest today is Phil Diamond, who is an expert in mediation. Let me read a little bio here. He is an attorney and a mediator who's practiced a wide range of civil litigation for over 35 years. His practice includes all areas of civil litigation, including real estate, construction, investor, and business disputes. He's also a settlement judge pro tem, there we go, and he served for 15 years as an arbitrator for the San Francisco County Superior Court Judicial Arbitration Panel. Again, listeners, get your pencil and paper handy because you're going to want to take great notes. He's going to teach us all about mediation. Phil Diamond, it is an honor to have you on as our guest.
Well, thank you very much. It's a pleasure to be here.
Welcome to the Best of Investing. All right, Mark, take it away.
Oh, hey, so Phil, what is mediation?
Well, that's a great question. And one of the things that I don't know that you mentioned or not, Edward, in addition to being a lawyer, I am also a mediator, and that really is the focus of my practice. People often ask what mediation is, and an easy way to think of it is as a structured negotiation. It's a form of alternative dispute resolution, which we call ADR, which is basically ways of resolving disputes other than through formal litigation in a court or through arbitration. And we'll talk about arbitration in a few minutes also. So if you think of this structured negotiation with the parties reaching their own agreement for resolution with the help of a neutral facilitator known as a mediator. The mediator is usually selected by both of the parties by agreement and typically retained and paid for by both of the parties. And a successful mediation results in a binding agreement, a settlement agreement, which is then enforceable if necessary in court.
So is mediation a result of a lawsuit, or is it something that you get into before a lawsuit?
That's a great question.
Yeah, it's a great question. It could be either of the above. You do not have to be involved in a lawsuit in order to mediate a dispute. Many of the disputes that I see are pre-litigation. Many of them are after litigation has happened, but disputes can be mediated at any time.
So I guess you could have a dispute with someone and say, look, let's mediate this now before we get into a big lawsuit.
Absolutely.
That gets really inexpensive. And isn't it true that when you do file a lawsuit nowadays, that in many cases the judges are now requiring mediation?
Well, that's a great question. They strongly encourage mediation. They cannot force parties to pay for a private mediation. That's really beyond the judicial power. But they do encourage the parties strongly to get involved in mediation because that settles cases and it takes the cases away from the overburdened court system.
And now this is kind of a behind-the-scenes question, but if you're the potential if you know the potential judge who is going to try this case and he suggests mediation, do you feel kind of obligated to do it? Because if you say no and the other party says yes and it goes to trial, is that judge going to remember that you said no?
Yeah, that could happen, and I think parties take the judge's suggestions to heart, and typically if a judge does recommend it, the parties do it.
And it's a little frustrating, though, because in many cases it's not binding. I mean, you can get into mediation, and if you don't agree on anything, all you did was just spend a bunch of money and you still have to go to court.
Well, I can think of a bunch of situations where mediation would be, a very interesting tool. I mean, people get into partnerships all the time. I mean, I've been in real estate for 30 years, and I've come across a number of real estate partnerships. In fact, I've been involved in real estate partnerships, and partnerships almost, by their nature, end up failing ultimately.
Well, it's more of a marriage than a marriage.
Well, exactly. And so oftentimes, as you're trying to, dissolve a partnership or you have a disagreement that you're trying to resolve, oftentimes there's a real benefit to having a third party, who has particular experience in handling that, come in and play. I mean, I would think that could save the parties an awful lot of money. Because let's face it, once you attorney up, lawyer up, and start talking lawsuit, I mean, you're committing to. I mean, nobody ever really wins in that situation.
Yeah, in fact, not to steal your thunder on this, but tell me if you agree with this.
Sure.
I think one of the big advantages to mediation is, when you are in camp and you've got your idea of how you think you are in the right, and the other party obviously thinks that party's in the right. An outside mediator is on an even playing field and can basically give the advice as to, look, this is probably what's going to end up happening if you go to trial. And so a lot of times that's a big wake-up call for the people who are in mediation to realize how expensive it's going to be and how a mediator might choose.
Absolutely, Edward. And actually, both of you have raised two great points that we should be talking about.
I mean, hey, we qualify for mediator. I like that. Okay, go ahead.
And I'm sure there'll be other great points raised as we go through this. Number one of the primary functions of a mediator is indeed to do what you just talked about, which is to bring a neutral, unbiased, objective set of eyes, if you will, to a dispute, and to help each side understand that there may be two sides to every issue that needs to be looked at. The other issue that you raised a moment ago has to do with the fact that mediation is voluntary, and that distinguishes it from arbitration. Which leads to the next issue I know that we wanted to talk about, which is what is the difference between mediation and arbitration.
Go ahead.
An arbitrator has many of the same powers as has a judge, in the sense that an arbitrator can issue and does issue what's called an award, which is, for all intents and purposes, the same thing as an order or a judgment that's entered by a judge at the end of a case. An arbitrator receives evidence, either through documents or through live testimony, and sometimes both, and at the end of that hearing, which is essentially a mini trial before the arbitrator then decides what the outcome is going to be for that dispute. Contrast that with a mediator who does not have that same power. He's not given that power by the parties or by the court. Rather, the arbitrator makes the outcome of the dispute for the parties, whereas the mediator assists the parties in crafting their own outcome. And one of the major differences is that in mediation, the parties themselves decide how is this dispute going to be resolved, not entrusting that to somebody else, be it a judge, jury, or
almost a kumbaya, so to speak.
And most contracts these days that I've seen in real estate, they have these arbitration clauses that basically say if there's a dispute, you agree to arbitrate as opposed to civilly litigate. And,
yes.
And I find that pretty interesting. And it's also interesting that there are people that don't like arbitration. Maybe we can talk a little bit about that
after we come back from break. All right, we have to go to our first commercial break. So here is the first trivia question. And I think I forgot to say that today's going to be music, if I'm not mistaken. Oh no, I'm sorry. This is I've got music, sports and movies.
We're mixing it up.
Mix it up a little bit. Okay. The music group Starship used to be Jefferson Starship, but what was their name before Jefferson Starship? You got to be from the 70s to know this one. The first 3 callers with the correct answer win a free 3-day, 2-night stay at the Lighthouse Resort. Their website is lighthouseforfun.com. And again, our new phone number, write this down, people, 888-912-1190. That's 888-912-1190 to answer this question. The music group Starship used to be Jefferson Starship, but what was their name before Jefferson Starship? 888-912-1190. Make sure to include your name, address, and phone number, and we will be right back. Welcome back to the Best of Investing. When we cut to the first commercial break, we asked this first trivia question. The music group Starship used to be Jefferson Starship, but what was their name before Jefferson Starship? Now, Phil, I think I saw your hand raised. What's the answer to that?
Jefferson
Airplane, that is
Absolutely.
correct. The first 3 callers to 888-912-1190 won a free 3-day, 2-night stay. We are in the studio with Phil Diamond, who is an expert in mediation and arbitration. And we're going to get into what's the difference between the two. I just want to make a quick comment. I was an expert witness in a securities case, investment securities, and it was an arbitration. So it was just like a little mini courtroom in a conference room where you had both parties there, and I was an expert for just one of the parties. But in mediation, because I've done that too, it's separate, isn't it? Eventually coming back together?
Well, typically, and we'll talk a bit more about how the mediation process works, the parties are going to be together at some point during the mediation process. Sometimes, and we'll talk about how I do it, the parties are also separate, both before and after.
And that's not just so they don't kill each other, it's
Well,
more of a strategy.
sometimes it is, actually. In family disputes, I've seen that happen, and we can talk a bit about that as well.
So Phil, how does the mediation process work?
Sure. So it begins as a general rule with the parties jointly agreeing upon who the mediator is going to be. And this is, of course, after they've decided that they're going to go through mediation. The mediator then typically speaks with the parties before the actual mediation itself, either directly or through their lawyers if they're represented by lawyers. And the purpose of that pre-mediation work is to make sure that everything is teed up, if you will, so that the parties come completely prepared to get the matter resolved when they're actually together in mediation. Typically, the parties will exchange what we call mediation briefs in advance of the mediation. They'll give them to each other and to the mediator. Those briefs tell each other and the mediator what the case is all about and why each side thinks that its side should prevail. So then, now fast forward to the mediation itself. Now, different mediators hold them differently. I'll talk with you about how I do mediations. I always make it a rule to talk with each side separately for a little bit before I bring the parties together. It's helpful for me to get to know them. It's helpful for them to get to know me. Helpful for me to be able to find out what is really motivating them and what their needs and interests are that are behind the dispute. It also gives me an opportunity to assist them for the next part, which is the joint session, to give them the benefit of my thoughts as to what is important for them to cover during that joint session and what may be important, to the contrary, to not cover. If there are hot button issues, for example, that may set the other side off and stop the other side from actually listening.
Well, yeah, because you're trying not to get personal in it.
Absolutely.
Yeah, keep that. Let me ask you a quick question on this. Because we were talking about the difference between arbitration, which is a little more binding, than mediation, which may or may not be binding. Do you find that clients act differently in arbitration versus mediation? Is there something psychologically going on with them where they know, hey, arbitration, this is like a court setting versus mediation? We might come to a conclusion, we might not.
Well, not really, and I say that because they know going in which setting that they're in, and if they're in arbitration, they know they're going to trial. And the mindset is we're not here to negotiate, we're here to convince the arbitrator that we should win. Contrast that with the mediation setting where they are there not so much to convince me as the mediator of anything, but to convince the other side as to the strength of their position. And
So do you find them being different?
very.
Okay, so
absolutely.
there is a difference in their attitude.
So if I'm trying to resolve a dispute that I have with someone, and would I want to look for a mediator that's an expert in the field that we're working in, or is it more of an art than a science?
You know, that's a great
great
question, and that question is asked frequently, and is often the topic of discussions among mediators.
What do you know about construction defects? as an example?
Exactly. I like to answer it this way. I think that the most important skill set that a mediator brings to the table is the ability, number one, to be able to work with people, to be able to engage people in a conversation and in a dialogue in a way that they can have an open mind as to not only their point of view, but the point of view of others. Secondly, the skill set that I think the mediator brings to the table is the ability to structure a conversation in a non-confrontational way so that the parties can get past the underlying issues.
Well, and they have to really feel that you are really independent.
Absolutely.
Even if I'm sure that in some mediations you may be looking and going, holy smokes, it's clearly toward one side versus another, but you have to really keep it pretty
Or one side's
even.
more reasonable than the other.
Yeah, exactly.
No, absolutely. The key to mediation is for the parties to have trust in the mediator to guide this process and to help guide them through this dispute toward resolution. Neutrality is absolutely key to that. The other issue that you raise is whether it's helpful for the mediator to have some substantive background in the area that is in dispute. And I would say that it certainly helps. It's not critical in all areas, but what is critical is if a mediator is mediating a dispute that he or she doesn't have substantive background in, that he or she be a quick study to be able to understand.
That's a good point, because I could see where it's maybe not quite as important, because if you go to trial, what are the odds that the judge is really going to know a lot
Or the
about
jury,
that
for that
specific- or the jury, yeah.
Exactly.
Yeah, you're not going to get all
Jury of
contractors.
peers, really?
Yeah,
I don't think
exactly.
so.
Exactly, which brings us to the question of why is it that people should even consider in mediation resolving their disputes? And one of the things that a mediator can help the parties to understand is the point you just made, Mark, which is that there are no certain outcomes in trial. Things happen in the course of a lawsuit all along the way, up to and including the time when a jury comes back with a verdict that can never be predictable.
Yeah.
So one of the advantages to mediation is a certain outcome, and a certain outcome now, as opposed to waiting a year or 2 or 3 or 4 years for an outcome that is totally unpredictable.
Well, not only time, but the expense of the
It's
trial.
only the attorneys that make out in this.
And no offense, Phil, but
None taken.
yeah. Okay.
So what are we talking about in terms of cost now, since we're talking about the money? I mean, mediation obviously is got to be a much more cost-effective, time-effective.
Sure, well, plus they split the cost, right?
Absolutely. So let's talk for a minute about what some of the advantages of mediation are, and in that context, we're comparing it with the alternative, which is a full-blown lawsuit, which starts with the filing of a complaint, and from that period on, going down through what we call the pleadings, and then through discovery, the depositions, the interrogatories, the requests for production, the things that can go on for years, and then finally through the actual trial itself.
This is a great show, because I know a lot of our listeners out there are either have gone through lawsuits or are contemplating lawsuits on either being the plaintiff or the
Yeah, if you're an
defendant.
entrepreneur or a real estate investor, you've likely been served more than once or twice.
Exactly.
So here are
this
some
is a good
advantages of this process. Number one, as we've already discussed, it's quick. You can have a mediation scheduled at any time when the parties are ready to do it. Secondly, it's an informal process. It's typically done in a private office. There are no formal oaths given by anybody. The parties determine themselves when it happens, how long it lasts, when there will be breaks, for example, whether there will be follow-up sessions, and if so, when. We talked about the fact that relative to litigation, it is extremely inexpensive. It's a fraction of the cost of a full-blown lawsuit.
Can you give us rough number? I know each mediator charges a different amount. Can you give any kind of?
Yeah, it's really hard to answer that, Edward, because every case is different.
Okay, somewhere between $2 and $2 million. Okay, that's it. All right, yeah. That's a wide
Are there
range.
hourly rates that one could expect that would be within a normal range in mediation?
Sure. And I'm just going to throw this out as a guess. I haven't looked at what would be typical recently, but I'm going to guess anywhere between $350 to $600 an hour, give or take.
Yeah, I was thinking about 500 an hour.
Yeah.
Somewhere in that range
Yeah.
for the mediator, and that's typically split by the parties. And by the way, it doesn't necessarily have to be only a two-party mediation. Many mediations involve far more than just two
Sure, because
parties.
you might have an insurance company and for that example.
Right.
Okay, we are going to cut to our second commercial break. We are in the studio with Phil Diamond, an attorney who specializes in mediation. It's been a great show. We're going to continue on with this. But here is our second trivia question. Matt Damon appeared in the remake of the movie True Grit, but who played his part in the original True Grit opposite John Wayne? Hint, he was a country singer. The first three callers with the correct answer win a free 3-day, 2-night stay at the Lighthouse Resort. Their website, again, is lighthouse4fun.com. Check them out. Call 1-800-912-1190. That's our new phone number, 888-912-1190 to answer this question. Matt Damon appeared in the remake of the movie True Grit, but who played his part in the original True Grit movie opposite John Wayne? And here's a hint, he was a country singer. 888-912-1190. Make sure to include your name, address, and phone number, and we will be right back. Yeah,
Wrap. Okay.
because then we'll add everything together and figure out the time.
That's fine. All right, 9:30. Mike's hot. 3, 2.
Welcome back to the Best of Investing. I'm Edward Brown, your host, and along with my co-host Mark Hunt of Pacific Private Money, we are in the studio with Phil Diamond, an expert in mediation. When we cut to the second commercial, we asked this trivia question. Matt Damon appeared in the remake of the movie True Grit. Just came out about a year or two ago, right?
Yeah, it was good.
It was a good movie. It was actually, personally, I liked it better than the original. But who played his part in the original True Grit movie opposite John Wayne? Hint, he was a country singer. All right, who knows the answer? Phil again.
Glenn Campbell.
Glenn Campbell, that is right. Very good. The first three callers with the correct answer won a free 3-day, 2-night stay at the Lighthouse Resort. Phil, take it away. You got some great stuff about arbitration and mediation.
Right, we were talking before the break about why people might want to consider mediation and what some of the advantages are. And one of the things that we hadn't talked about yet is the fact that contrary to the litigation process and a public trial, mediation is confidential. It's behind
Private.
closed doors.
Yeah.
It's a private process.
Oh, that's a good point.
And if there are
Absolutely.
issues in a mediation dispute that the parties would not want to have aired out in public, mediation is the way to resolve them. In addition, there are certain privileges, we call the mediation privilege of confidentiality, which provide that things that are said during the course of a mediation are to be kept confidential. We talked a bit before about the fact that the parties control both the outcome and the timing of the process. Most importantly, though, and this contrasts with the litigation or even arbitration process, is the fact that it is a collaborative process and the parties can come together and craft a creative outcome in a way that neither an arbitrator nor a judge or a jury could do.
Well, I just like the fact that, you know, if you have a partnership and you've got a dispute, this is such an advantageous way to bring a third party in, someone who
Sure.
is adept at bringing parties together.
Unless you're trying to punish the other person.
Right,
Because
exactly.
in a trial, it's a win-lose situation.
Exactly.
But mediation, it's, look, I may not like you, but we got to come to some, unless I'm trying to punish you, you don't want to spend a bunch of money. I
And
don't
the
wanna
issue
spend
might
a
not
bunch
be
of money.
lawsuit worthy anyway, but still there's,
Yeah.
again, I've just been involved in enough partnerships to know that, always gets to a point where you feel like I'm doing all the work and he's doing nothing, or this the way we're divvying up the profits just isn't working, or,
Right.
and yet you don't have the relationship or the ability to settle it amongst yourselves. There's too much emotion involved.
Yeah, that's a good point.
Absolutely. The mediator is there as a safety valve, if you will. Think of it as a pressure cooker with that relief valve on top to
Yeah.
help that emotion get out of the problem and to resolve it by looking rationally and helping the parties looking rationally at how to do that. And Mark, the point that you raise, and it's a great one, is that it's perfect for those situations where the dispute is between people who have a pre-existing relationship that they want to preserve. For example, a business partnership.
Wow. So do you find that after mediation, a lot of times they can get back to business again?
Absolutely.
Wow, that's
Absolutely.
It's like marriage counseling.
Well, in a way it is.
that's true.
In a way it is, and the gold standard really for mediators is not only getting the dispute resolved, or I should say more properly, helping the parties to get the dispute resolved, because of course they're the ones that ultimately control whether it's resolved or not. But then the next step, and that is helping to resolve the relationship between the parties that brought the dispute to you to begin with.
Yeah. Well, you mentioned marriage counseling. I wonder, instead of hiring a $500 an hour attorney, you hire a $150 marriage counselor for a non-marriage situation. That's not bad, because they know the psychology, right? Not a bad idea. Sorry, that's kind of put you out of business.
No problem. One of the questions you asked earlier also, Mark, was why is it that some people are resistant to put arbitration clauses in their contracts?
Yeah, I see that a lot.
Yeah, there are actually a couple of different schools of thought on that. There are some people who are totally pro-arbitration. There are others who are against it. And some of the reasons that people may want to shy away from arbitration are, number one, it does have an expense associated with it, and particularly if there is going to be the same type of discovery, which we talked about earlier, that there would be in a lawsuit, and oftentimes there is.
But who would be against mediation if you could make it binding?
Well, it is binding by definition, with the fact being that it's binding when the parties reach an agreement.
Okay, so who would be against that?
I don't know who would be against it.
I mean, any contract that you're...
Well, you wouldn't be, but we were talking more again, the arbitration side. There are people who would prefer a full-blown jury trial than having an arbitration clause in a contract.
Oh, okay, so we're not comparing mediation,
No.
we're comparing just a straight up
Arbitration,
lawsuit
right,
versus
yeah,
you have to do
versus
arbitration.
lawsuit.
And a couple of other things that people don't always know. An arbitration outcome is, with limited exceptions, non-appealable. Which means that if there is a crazy outcome, it's final, it's over. And of course the good news is it puts an end to the process and an end to the expense. The bad news is arbitrators are not bound to follow the law or even rules of evidence in the process.
Hold on though, if you go to full-blown trial and you don't like the outcome, you can at least try to appeal. A lot of times the judges won't let it go further, but at least you have the opportunity to try to appeal it.
Right.
But in arbitration, you don't even have that ability.
Right.
Wow.
Yeah.
You really take your chances on that.
And that's not widely known, but that is one reason that there are some people that as a matter of habit, will not put arbitration clauses in their contracts.
Well, I guess the people that are against the arbitration clause would be the person who believes that the person who wrote the contract, who included that, obviously did because they felt there was an advantage to them in doing so.
Sure.
That's a good point.
So one of the things we haven't talked about is, are there any disadvantages to mediation?
Yes.
And the answer is, like everything, sure there are. But they all arise from the fact that it is a voluntary process. And because it's voluntary, number one, you cannot force the other side to engage in the mediation process.
Yeah, but that's not a disadvantage to mediation. That's just somebody may not say, listen, I don't even want to mediate it, but that's not a disadvantage to mediation.
I would agree.
It's like the husband who says, I am not going to counseling.
And of course, the next part of that is that there is no guarantee that there will actually be an outcome in the mediation.
And at that kind, all your I was going to say part of it you're talking about then is the cost of mediation.
Sure.
So that's a downside.
Sure.
But potentially, if you mediate and don't come to a conclusion, I wonder if there's any strategy situations that come up in that wouldn't have come up. You know what I mean?
Yeah, so let's talk about that in a couple of contexts. Number one, people should understand that well over 90% of all cases that are filed get settled at some point anyway.
90%, wow.
So,
So the question that I ask the parties as a mediator usually is, do you want to do that now? Or do you want to do it 2 or 3 or 4 years from now after you've spent tens of thousands or hundreds of thousands
is that a
of dollars
great
to
leading
get to that
question?
point?
That's a great lead. That really puts people in the mindset of, it's going to cost me a lot of money later on, and I'm probably going to end up settling. I bet a lot of people come in right away and they go, I refuse to settle, I want such and such.
They do, and my role as a mediator, Edward, is to help, and this is how I would define it, is to help the parties to fully understand the issues, the risks of going forward through trial,
Absolutely.
and the costs that will be associated with it, and then based upon that full set of information to make an informed, what is really a business decision as to what to do.
Well, that's a great point, because we were in mediation one time because we had a contractor we thought was just the contractor from hell. And the amount that was in dispute ended up being about $35,000. And it was just enough to be painful to say, you know what, we went to mediation, and emotionally, this was my own house. So, I was charged about it, and so was my wife, but we both made the business decision that it was best to settle for, I think it was $15,000 versus, we might have won, we might have lost, but for sure we were going to spend at least $25,000 in court costs. So that's where you have to really put your business head on.
Exactly, and of course the other cost associated with going the litigation route is what we sometimes refer to as the transactional cost, which is the time it's going to take you from what you otherwise should be doing with your life.
Absolutely.
And the emotional investment during the entire time that the process is on
and
file.
putting your files together, knowing, okay, in 6 months we're going to be going and we got to practice this. Absolutely.
So a couple of other things that we were going to talk about if we do have time. One is in what types of disputes is mediation appropriate?
Okay.
And the simple answer is really all disputes.
All disputes, yeah. All right, Phil, stick around. We're going to be cutting to commercial break. Whatever we don't cover today, I know we have a lot more information. We'll definitely have you on again. We've been in the studio with Phil Diamond, who is an expert in mediation. And Phil, before we forget, how do people get a hold of you if they are interested in hiring you as a mediator?
Sure. My firm is Diamond Dispute Resolution, www.diamonddisputeresolution.com, and you can reach me with questions at 415-492-4500.
Excellent. Okay, we are cutting to the third and final trivia question. Who is the only Yankee to join the 3,000 Hit Club? The first 3 callers with the correct answer win a free 3-day, 2-night stay at Lighthouse Resort. Their website is lighthouseforfun.com. Call 888-912-1190. That's 888-912-1190. Write that down. To answer this question, who is the only Yankee, and obviously we're talking about the New York Yankees, to join the 3,000 Hit Club? 888-912-1190. Make sure to include your name, address, and phone number, and we'll be right back.
All right, so cut at 10. Mike's hot for segment 3, 2.
Well, welcome back to the Best of Investing. We had a great 3 segments with Phil Diamond, who is an expert in mediation. We're going to have Phil, we're definitely going to have you on again. And here was our question, our third and final trivia question. Who was the only Yankee to join the 3,000 Hit Club? Mark, you're a big baseball fan. Who was that?
Derek Jeter.
Derek Jeter,
This
yeah. Not Lou Gehrig, not Babe Ruth.
No.
Not the Babe, but Derek Jeter, and he did it this year. And Mark, we received an email that I'd like to ask you here.
Sure.
How is the process of getting a loan with your company, Pacific Private Money, different than getting a loan with a bank? That's a great question.
Oh, God, I love that question. So, my company's Pacific Private Money, based in Nevada. We do real estate loans. We like to say that we do the real estate loans that the banks don't do, but that's not so much true anymore as the banks just really aren't doing many loans at all anymore.
Maybe they ran out of money.
Well, but let me go back and answer the question. Bank loan, painful. Private money loan,
Not painful.
not painful, no.
I mean, for the process.
For the process is really, the process in getting a private money real estate loan is amazingly simple, and particularly if you are one like a lot of our clients are right now. We're talking people with either good credit or fairly good credit, people with money, with experience, real estate experience. You go to a bank right now and try to get a real estate loan for an investment property or to buy a bank-owned property or a short sale. Good luck. First of all, they're going to drag you through such a time-consuming process that the deal you were trying to get is going to be gone. So
That's a good point.
So we get an awful lot of applications from people who are looking to leverage the capital that they have into more properties. So maybe some of our clients may have $100,000 or several $100,000, and they're buying properties, all over the Bay Area. Maybe they're buying in Oakland, maybe they're buying in Marin, maybe Solano County, maybe Sacramento County. Oftentimes, our applicants are focused in a certain market where they're very comfortable and they know the real estate, and they've got a certain amount of capital and they've got some experience buying, fixing, and flipping, and they're looking to take that capital base that they have and leverage it. In other words, multiply it by borrowing from a private money lender like Pacific Private Money, and being able to buy more real estate. So instead of all cash, for $150,000 or $200,000 on a bank-owned property, they could borrow up to 65% of the purchase price very, very easily from companies like ours. And there are an awful lot of private lenders in the Bay Area. Pacific is one of several dozen very, very fine private money lenders, but we all tend to operate under the same core principles, and that is we don't do 80% financing, generally speaking. We generally do 65% of the purchase price.
That's what the banks are.
Right, because
too.
again,
What kind
private individuals are funding these loans, and so we need to be more
ultra conservative?
Well, we need to be
Sure.
conservative, right? I mean, the banks lost a lot of money making 80%
Well,
loans.
because the government goes ahead and
Right.
backs them up.
And we don't know which direction real estate prices are really heading. I mean, some people feel as though it's this, it's the end of summer 2011. We should be at the bottom, and things may go up from here. But then other reports out there seem to indicate that maybe we could have further declines. That maybe a year from now we might be talking about, maybe is now the bottom. So
Yeah. And what kind of rates are you giving your borrowers right now?
well. The borrowers, the good news about getting a private money loan, also known as a hard money loan. I just like the term private money better than hard money, but they used to be 12% and 5 points was not unusual. In fact, depending on where you're buying property, you still may get quotes like that from some private lenders out there. But there's an awful lot of money out there looking for higher yield, and so our investors are plentiful right now, and as a result, as are other private lenders, and we're all looking to place that money in good loans. So what does that mean? That means that pressure is driving rates down. So now it's not, we've done loans as low as 8.5%, 9%, which for private money is pretty darn low. I mean, you're not talking, this is not long-term financing, this is not 30-year loan. These are 12, 24, maybe 36-month loans, but generally speaking, it's a means to an end. There's an exit strategy. There's a business plan, basically. I mean, we're making loans to real estate investors, not homeowners. Homeowners, I don't know of any homeowner, right? I don't know of any homeowner who wants to borrow money at 9%.
No, but from a business perspective, I can see where because we used to have this too, that people, investors will want to borrow from you, even if it's a 3% higher in rate, just because they don't have to go through all of the hoops that the banks require and the timing, and then potentially you get quoted one thing, and by the time they come back, it's something else.
Well, what does make it a little bit hard is that someone who hasn't borrowed privately before oftentimes gets a little bit of sticker shock. So they're hearing bank rates at 4%, so they're going, well, maybe I can get one at 5 or 6.
Well, but not 4% for commercial real estate.
Right,
You're not getting that
that's
kind of
exactly right. But I'm just saying again, people will call oftentimes, and when I tell them, when I give them kind of a quote range in terms of points and interest rate, oftentimes there's a little bit of sticker shock if they've not borrowed privately before.
And if I'm a potential borrower and I'm paying you 8.5%, what are you paying your clients?
Our clients are generally getting 1% under the note rate.
So 7.5%.
Yeah.
So if clients want to invest at 7.5% at 65% loan to value, that's a pretty darn good conservative.
It is, and our investors on average earn more than that. Usually 8-9% is a more common rate, because we're not doing a lot of 8% loans to borrowers. Again, that's like the lowest rate.
Okay, but basically it's a 1% difference.
It's a 1% difference.
Okay.
So
Now, you know what? With the few minutes we have left, I wanted to find out, because you had mentioned that there's a bunch of new stuff going on with real estate.
well, this
breaking
week,
news.
Yeah, well, the breaking news is that it's the foreclosure report basically. The numbers for August have come out, and foreclosures have spiked. In other words, notices of default, which is how foreclosures start in real estate, went up. In California, get this number, it's up 70% month over month from July. And really what that
Wow.
means, what effectively has happened is, and this is really all driven by Bank of America. Bank of America decided, you know what, we're done allowing all these non-performing loans to continue. People have been staying in their homes and not paying the monthly mortgage, and the banks, at least B of A, has decided, you know what, we're just not going to file right now. There was
But
the
they also
robo-
get their hands slapped by.
Well, that's just it, the robo-signing, all that stuff. So
Robo-signing.
most of this spring and summer, there have not been a lot of new additions to the pool of properties under foreclosure. That's now starting up again. So it's up 70%, and in fact, notices of sale in California are up 6%.
So theoretically, prices should be dropping again, wouldn't you think?
Well, yes and no. Here's the thing, a lot of real estate investors, and I'm plugged into the real estate investment market because these guys are coming to me all the time to look for money. But you know what? Everyone's been waiting for you remember the second wave,
Yes.
the tsunami from the so-called shadow inventory? Well, this is actually going to be very welcome among real estate investors. So I don't necessarily see this being meaning that there's further doom and gloom in real estate. No. This is necessary. This inventory has to get off the bank's books.
Oh, so rather than trickling it through, it's going to come a little bit more in a larger way.
It's not first of all, it's not sustainable for millions of people to be living in their homes and not paying their mortgage. It's just not
It's
realistic.
un-American. Phil, go ahead.
I might mention, apropos of what you were just saying, Mark, that mediation is a great way to resolve loan workout and distressed property disputes.
Really?
Absolutely, because you've got parties on both sides of those transactions with interests that don't have to be adverse to each other. You've got banks that typically don't want to take the properties back.
Yeah.
You've got lenders that may be willing to work out some arrangement short of litigation.
Now, is that a mediation situation?
Sure,
Or is that
it can
just a
be.
loan workout, or just, unless there's a specific dispute within the contract of the loan, it could be just a situation of, gee, I can't pay my mortgage, what's the best deal you
But
can give me?
there's companies out there that have sprung up, and a lot of them have gotten in trouble, who are charging people
Yeah.
money to try to get permission to do a short sale from the bank, and oftentimes, these people are just they're quacks. Some of these companies.
Some of it,
So
yeah.
so going to a mediator, that's brilliant.
Thank you.
I knew you were just waiting to ask that question.
I didn't invent it, but thank you.
Yeah.
So anyway, so Bank of America has opened up the floodgates, so to speak. But again, it's all relatively speaking. I mean, they just weren't filing foreclosures for most of spring and summer. And so now I think again this is welcome news for real estate investors. This is welcome news for people who buy at the courthouse steps. There's not been a lot of good inventory available at the courthouse steps, and real estate investors are poised and ready to buy California real estate at the courthouse steps, and put that property back to productive use.
Right. Mark, just wanted to tell you that, everything I hear from everybody is that, you're a very honest person. So I really appreciate you coming to be my co-host on the
We
show
try to tell
here.
it like it is
Tell it like
here
it
at
is.
the Best of
Okay.
Investing.
And Phil Diamond, expert in mediation, thank you very much. We're going to have to say goodbye now. Thoughts for today. How would you handcuff a one-armed man? Ever thought about that? And if outer space is a vacuum, who changes the bags? I want to thank my engineer, Hunter Hornstein, for orchestrating this show. Tune in next week to the Best of Investing. We're going to be giving away 9 more free vacations for answering trivia questions. Thanks for listening. On behalf of our team, I'm Edward Brown, wishing you the best of investing. So long.